Picture New York City. Not modern New York City. New York in the 1950s and 60s. This New York. Cabs racing around busy streets. People walking down crowded sidewalks. The general hustle and bustle of the Big Apple. You walk around the city surrounded by a diversity of people and of architecture. But you're also surrounded by the effects of urban renewal. During the period of urban renewal, the federal government forced over 300,000 people from their homes.
What was once a run-down, dying section of the great city of New York has been recreated.
The slum means disease and crime. The new projects mean health and happiness.
Block after city block was demolished in the name of progress and economic development. At this time, New York City was allowed to condemn private property and turn it over to private parties for redevelopment. Robert Moses was in charge of many of the projects that displaced New Yorkers and destroyed so much of the historic fabric, hand-picking who would be able to take over the condemned land, and usually basing his decisions on political favors. Moses was also responsible for nearly every highway in New York City, including the Long Island Expressway, which was influential in encouraging the urban sprawl that was linked to automobile use, and that gave urban decline an extra push. Although residential areas were hit hard in the name of urban renewal, they were not the only places to suffer at the time. Penn Station. At its peak in 1945, Penn Station had seen more than 100 million passengers a year. But by the late 1950s, passenger volumes had declined sharply with the jet age and the interstate highways. The cash-strapped owners of the station claimed that the cost of maintaining the structure had become prohibitively expensive. They decided to tear down the station to replace it with something less expensive and more profitable, an office and sports complex. Protesters attempted to stop the destruction of the ornate building, chanting, "Don't amputate, renovate." Despite these protests, they tore down the McKim-Mead and White Monument in pink granite in October 1963. The New York Times wrote that until the first blow fell, no one was convinced that Penn Station really would be demolished, or that New York would permit this monumental act of vandalism against one of the largest and finest landmarks of its age of Roman elegance. Ada Louise Huxtable, the architecture critic for the time, said that any city gets what it admires, will pay for, and ultimately deserves. We want and deserve tin can architecture in a tin horn culture, and we will probably be judged not by the monuments we build, but by those we have destroyed. The destruction of Penn Station earned national and international attention, and its demolition is considered to have been a catalyst for the preservation movement in the United States. This New York is also the New York of Jane Jacobs, the well-known author of The Death and Life of Great American Cities. Jacobs helped to organize grassroots efforts to protect neighborhoods from slum clearance, specifically opposing the likes of power broker Robert Moses. And don't forget that in 1966, the federal government, in response to all of the destruction of urban renewal, enacted the National Historic Preservation Act. Only 1 year before the National Historic Preservation Act came into effect, New York City Mayor Robert Wagner had signed the New York City Landmarks Law into effect in 1965. Again, this was in response to the growing concern over the demolition of culturally significant buildings like Penn Station and other historic blocks. In the midst of all this preservation controversy sat Grand Central Terminal, a beautiful granite Beaux-Arts masterpiece. Not quite as busy as Penn Central had been, Grand Central had seen its fair share of traffic as well. At its high point in 1947, 65 million people passed through the train station. But just like the owners of the demolished Penn Central, the Grand Central owners were trying to find a way to keep their head above water at a time when rail travel continued to decline. In 1954, there was a proposal to completely tear down the building and replace it with an 80-story, 4.8 million square foot tower, a glass cylinder designed by I.M. Pei that would have been 500 feet taller than the Empire State Building. That plan was, fortunately, abandoned. An office tower north of the terminal building, replacing the terminal's 6-story office building, was proposed instead in 1955, approved in 1958, and the Pan Am Building, which is now the MetLife Building, was completed in 1963. This bought Grand Central at least a little time, but with continuing economic struggles and facing bankruptcy by 1968, Penn Central Railroad, the owner of Grand Central Terminal, unveiled plans even bigger than the Pan Am Building. They offered up 2 designs by Marcel Breuer for skyscrapers to be built on top of Grand Central Terminal. These designs, each proposing buildings over 50 stories tall, were submitted to the New York City Landmarks Preservation Commission in compliance with the Landmarks Law. To the delight of preservationists, the plans were rejected. Penn Central filed suit against the city, arguing that under the city's preservation law, with the regulations in place limiting what the company could do with its building, the company would never survive because it could never turn a profit. 10 years after the Breuer designs were rejected, the Supreme Court delivered the Penn Central decision, one of Supreme Court Justice William Brennan's most important decisions, one of the most important decisions to land use law in general, and probably the most recognizable case in historic preservation law. This famous case addresses the concept known as takings, which comes from the Fifth Amendment of the Constitution. 12 simple words: nor shall private property be taken for public use without just compensation. It's this short phrase that has placed constitutional restrictions on the power of the government both to acquire property and to restrict private property rights. It's the impact of these 12 simple words that I'm going to address in this unit called takings. The concept of takings and how private property is impacted by the Fifth Amendment plays out in 2 very different contexts that you'll need to understand. The first way is through what's called a condemnation action. This is where the government invokes its power of eminent domain. In eminent domain cases, the government concedes that it's taking property from someone. There's no question that there's a taking involved. This is what you commonly see, for example, when the government wants to build a highway that's going to run through someone's private property, and they need the land for the infrastructure project. The major issues in these types of cases are usually questions about just compensation and about public use. In the realm of land use law, eminent domain cases have been some of the more dramatic and more well-publicized actions that you come across. They frequently show up in the news. People fighting the government to keep them from tearing down a favorite building, fighting to prevent pipelines going through their neighborhoods or highways through their backyards. Eminent domain cases are relatively common. The second context where takings come into play are in regulatory takings, or constructive takings. These are the opposite of condemnation actions. Here, the government has created some kind of law that encroaches on someone's private property interests, but the government doesn't actually admit that it's taking property. In this kind of takings case, the property owner is the one that files an inverse condemnation action against the government to try and get compensation for what's essentially an unacknowledged taking. With these constructive or regulatory takings, you have people fighting restrictions being placed on what they can and cannot do with their property. There can be zoning challenges, ADA violations, wetlands designations, even negligent behavior. For example, in May 2015, a federal court found that government negligence in the midst of flooding from Hurricane Katrina constituted a taking of property by the federal government. In St. Bernard Parish Government v. United States, the court found that the Army Corps of Engineers' negligent design and their failure to maintain the Mississippi River Gulf Outlet Canal that was built by the Corps in the 1950s exacerbated flood damage in parts of New Orleans. That increased flooding, even though it was only temporary, wrongfully deprived landowners of the use of their property and constituted a taking. You might ask, why are takings important to me? In the context of preservation, it's important for you to understand takings, because when you're trying to protect historic sites or properties that aren't owned or controlled by the government, you may encounter resistance from people who believe they should have the right to do what they want with their own property. And one of the arguments used against historic preservation regulations or ordinances has been takings. In this section of the course, I'm going to address a number of issues related to takings. First, you'll learn where private property rights come from. After that, you're going to learn about eminent domain, or condemnation actions. In the eminent domain discussion, I'm going to address the authority of the government to take properties through condemnation proceedings. I'll talk about the case law that's created precedent in eminent domain cases, and I'll address the most recent and controversial decision of Kelo v. City of New London. You should take away from this part of the unit what's considered an acceptable public use of private property. And finally, you'll learn about inverse condemnation, or constructive or regulatory takings. In this last section, you're going to learn how far the government can go in regulating private property before they have to compensate someone for having taken their property. As always, if you have any questions about the materials or problems with the technology, please don't hesitate to email me. Now move on to the short quiz about what you already know about takings, and then a brief reading on property rights. I'll return to discuss eminent domain in the next video.